I'm going to go through the existing proffer statutes real briefly, just to highlight how it works and what it evolved into over the years, and then I will talk a little bit about sort of the predecessor legislation, which resulted in 15.2-2208.1, sometimes known as sort of the Kuntz Bill or the Unconstitutional Conditions Statute. And then I'm going to talk about this legislation itself. Conditional zoning evolved in Virginia because in the early 1970s in Northern Virginia there was substantial growth in Fairfax and other localities there that simply could not be addressed in any reasonable way with the existing legal construct of the day. So imagine yourself in 1974 in a rapid growth mode in Fairfax County. You're a developer, you want to develop a subdivision, and there are road improvements that are needed, and Fairfax looks at you and says, well, I can't approve your development because the road's inadequate. And the developer says, but I'll pay for the road. If you give me the development, I'll pay for the road, I'll take care of it. And Fairfax said, no, I'm sorry, there's no legal way to get that done. You're denied. Circa 1974. Well, fast forward to the 1980s, and the developers were looking for a way to solve that problem. How do we get our projects approved? We got our projects approved by getting conditional zoning passed. Some states have gone to impact fees. That could have been approved. That could have been a route that was used. They chose not to. Instead, they said, well, impact fees sounds like things government can do to us. We don't like that. We prefer the idea of voluntary proffers, that we can cook up our own regulations and we can cook up our own ways to address it. And so they adopted the predecessor to what's now 15.2-2303, which is sometimes called Northern Virginia proffers or old conditional zoning. It's pretty much Wild Wild West proffers, as long as it meets the Nolan-Dolan roughly proportional. In other words, it's not taking. As long as it's not taking, then have at it. Now that's been changed some over the years with some amendments to it, but that was the original idea, is we want to give developers the maximum flexibility to address impacts, so that when Fairfax says, you've got an impact, sorry, I can't approve your development, the developer can say, but I just did, see? Approve me. And so that was the idea behind 2303. Other localities and other developers in other parts of the state said, well, we want in on this. We want to have some ability to be able to proffer to mitigate our impacts. There were other places with high growth around the state. Virginia Beach, Henrico, Chesterfield, other places around the state. And the developers there said, well, we're getting turned down, and we want to have those proffers that they use in Northern Virginia. Well, there was sort of a compromise made to decide that we're not going to expand old conditional zoning around to the rest of the state. And so they adopted the predecessor to what's now 15.2-2297, which is called new conditional zoning. I call it sort of inadequate proffered zoning because it is fairly limited. It's quite limited. And we'll see under this new legislation if we're back there again, frankly. Some high growth communities said, well, thanks very much, General Assembly, but that still doesn't work for us. We need to have cash proffers like they're getting in Northern Virginia. We need to address off-site impacts, which you can't really do under 2297. We need to have dedications of property and things like that they can do in Northern Virginia, but we can't under this existing statute. And so they adopted the predecessor to 15.2-2298. If you're a high growth locality, which as we heard just a moment ago, can be like Lee County. I mean, it's not a very high standard because it's a very long period of time. And if you're a very small locality like Lee County, 5% can be, what, 6 people, 7, something like that? I'm kidding. But the bottom line is, meet the test and you're in. 2298 was a significant improvement for high growth localities. It allowed cash proffers like in Northern Virginia. It had some restrictions on it that you still had to meet. So it wasn't just Nolan-Dolan, roughly proportional non-takings. It was also having to that also had to, rise, the need arising out of the rezoning, et cetera, and a number of other things. So that's pretty much the history of the beginning of those things. Over the years, the General Assembly has tweaked these provisions to fix perceived things that were wrong with it. There was a big litigation in the early 1990s that when I was a very young associate, actually I helped defend Fairfax in the big downzoning in the early 1990s. And at that time, there was a lot of legislation that went into all three of those sections that talked about, well, what happens when you've dedicated real property of substantial value or construction of substantial public improvements? And so you've actually committed to do all of this, and yet they just downzoned me. That's not very fair. They can hold me to, this, but then there's a text amendment that says I can't do but half the FAR. They cut my density, but I'm still got to build the road. That's not very fair. Well, they adopted what's now basically B, C, and D in each one of those sections to address that and actually vests rights in those particular densities, uses, and FARs, as long as they can show that they've dedicated real property or construction of substantial public improvements. Other things that have been tweaked over the years, there was a problem in Northern Virginia, or a perceived problem, with folks saying, well, we want you to proffer that you can form an HOA. The HOA is going to charge fees to everybody. The HOA then is going to do public improvements. So to kind of get around one of the issues there, the General Assembly said that's a no-no. So they adopted that. There have been restrictions on cash over the years. You heard some of it earlier, some reporting, some restrictions, some things like that. To the localities that have that. They've also made, in some ways, proffers a little more flexible over the years. For example, proffers from time immemorial were to be submitted in advance of the public hearing. Well, that kind of always made sense to me as a local government lawyer and procedural wonk, because the fact is the public ought to know what the development is before there is a public hearing on it. And it shouldn't be something that's done in a back room or done after the fact. I should know exactly what it is I'm speaking for or against. And so the rule always made sense to me, but a number of years they changed it and said, well, it's supposed to be in advance of the public hearing, but it can be after the public hearing as long as it doesn't substantially impact things like density. And as a local government attorney, I've always kind of cringed when my clients turn to me and say, in the middle of a public hearing with a room full of angry people and a bunch of elected officials on the chopping block staring at me going, well, does that substantially affect that or not? Does it substantially affect the overall development? Good question. Usually on those types of reasonableness, overall feeling kind of questions, I turn back to the legislators and say, that's why they elect you to make those kind of calls. So there have been a number of tweaks over the years, but all in all, the process has worked. It's been a good system for Virginia. Developers have been able to mitigate impacts. They've been able to get their projects approved by and large, except where, honestly, they just couldn't muster the legislative votes on the governing body, and that's the way it ought to work. And that is sort of what brought us to the current situation. The home builders basically drafted and filed this bill, had it filed on their behalf. And there's some substantial problems with the bill. I think even folks that are developers, even folks that are home builders, either understand that there are flaws in this, or they will quickly learn that there are flaws in this as it's implemented. There are a substantial number of problems with the bill. One of them is that it actually ties the hands of developers themselves to mitigate things that are actual impacts. It also raises the penalty to local government to such a severe level and make playing in the proffer game so risky that some local governments are simply saying, I don't want to play that game anymore. Proffers originally in the 70s and 80s were created in order to make a more flexible process for developers so that they can come in and address impacts, and so that that could remove problems that obstruct a legislative approval. Now with this, they are in fact prohibited from proffering a number of things. I mean, for example, if it's not a granular analysis. If it's not directly attributable, if that proffer doesn't directly attribute some impact, and the impact is directly attributable, I mean, that's pretty one-on-one. And you've already heard that maybe your fees need to go up, maybe you need to hire experts, maybe the developers need to pay for experts to do that analysis for you. You know, that's certainly, I think, helpful. But I will say, in the end, even with an expert's analysis and even with an expert's advice, it is going to be very difficult not to have a Monday morning quarterback come back and challenge decisions as not being directly attributable. And it may be that developer who wakes up Monday morning and says, I really regret that. Or maybe the economy changes and they don't really want that condition at all. Or maybe in the heat of the battle, they're willing to submit that condition knowing that it might be arguably unreasonable, and I'll threaten them later with it. Or maybe it's a subsequent property owner that comes in with a proffer amendment and wishes to challenge it. I mean, there's so many traps for the unwary. The way I describe this to people is, it's essentially they've created a giant pit with a bunch of lions at the bottom of it. And they're expecting local government to sort of walk the edge of the pit. And if you wish to walk around the edge of the pit, there's about 7 ways, maybe 8 or 9, that you can fall in, and there's only one path to safety. And if you survive the 8 or 9 ways that you fall into the pit, then good for you. If you don't, then you are subjected to all sorts of penalties, damages, attorney's fees, and my least favorite thing that the General Assembly has ever done, judicial rezoning, which is unconstitutional. And that is essentially a remand to local government with a decree from the judicial branch that they legislate a certain way. That's a violation of the separation of powers. It's illegal. The General Assembly's been told it's illegal. We have yet to see a case where it's actually been applied. But I don't see how a judicial decree ordering a particular legislative result is consistent with the separation of powers. So there's a number of problems with this bill. I guess one of the things that I have in your materials is a marvelous letter that was written by Sterling Reeves, who's a friend of mine. He's a Hanover County attorney, and this is a little bit of a setup because I have the chief planner from Hanover here on the panel. I figured, yeah, let's see how he gets around this. That's fine. That's fine. No, Sterling knows that that we have this letter. Bottom line is, the letter is actually a letter to Terry McAuliffe in advance of the veto session, asking that he veto the bill and giving reasons why the bill is flawed. And there were no substantial changes made in the veto session to the bill. So the criticisms that he has in this letter are in fact criticisms of the final law that was adopted. And if you go through the letter, he points out, number 1, this is a brand new code section. It is in conflict with existing law. The existing law, which I just mentioned, 2298, 2303, has not been amended. So you're kind of setting up a conflict within the law. Number 2, and this is the one I mentioned earlier, it curtails the ability of developers to address impacts. There's a number of local governments out there, and I've served in several, that are pro-development, that are pro-economic development, that want to see things approved. There are others that are somewhere in the middle. I don't know of any local government that doesn't want good development approved where they want the development. That's what we do as local governments. I mean, we're all about good growth and development. There are local governments that wish they had the growth and development of some other local governments. But this actually puts handcuffs on the developer to address impacts. And when there are legitimate impacts that cannot be mitigated through this process, the local government then is put into a tough spot. Do I approve this thing, even without these things being mitigated, or do I turn it down? And maybe there's an angry horde of people who were there at the dais or at the podium complaining about the proposed development. But yet, you know, it's a good economic deal for the county. How do I deal with those issues? I think that certainly the allegation was that there were abuses by governing bodies and governing officials, sort of twisting arms and demanding things and this, that, and the other. If in fact that were true, I would say that this is an overreaction to that. There are other ways to get at that than what they've done here. Because I think they've unfortunately tied the hands of developers and localities to reasonably work together. One of the things that they have done here is talk about conditions that are formally or informally requested by the locality. I pointed out to folks on the General Assembly during the session that this was very difficult to understand how that could be applied. Certainly there are folks that will attempt to use this against local governments that will argue that this is a remedial statute, needs to be interpreted broadly. And if that's the case, then there's very little that a local government official or a staff person can do without formally or informally requesting, suggesting, or requiring a condition. I've had some of my colleagues say, well, we won't actually mention a condition, we won't actually ask for anything, we won't suggest anything, we'll just point out impacts that are not mitigated. Okay, I'm a pretty clever lawyer. If I'm working on the other side, it's very easy for me to say, well, they suggested impacts that need to be mitigated. That's an informal suggestion that I proffer something. I win. And I cannot say there's not a judge out there that might adopt that reasoning. The next thing, number 3. Proffers are deemed unreasonable, which is a complete shift in the normal way we do business in local government. What we do legislatively is deemed reasonable. That's a good thing. And the reason it's a good thing is that there are tough calls that need to be made. There are winners and losers. There are lines to be drawn. And somebody has to draw those lines. And we elect people to do that. There's a legislative process. And for whatever the flaws are in that legislative process, we need to let it work and not sort of pull the rug out from legislators that are trying to do the right thing. So this basically turns the fairly debatable test on its head, and essentially, instead of things being deemed to be fairly debatable, they're actually deemed to be unreasonable. Let that sink in for a minute. In other words, if local government really can't prove with clear and convincing evidence, as we'll see in a minute, that these things actually meet the test, and they don't. Just the way it is. In 3, he talks about specifically attributable. Specifically attributable is a serious problem. It's like putting a thread through a needle. Now, I don't do much sewing, but it's tough to do. You've got to get through that hole, and you've got to prove that condition matches up to that impact on the other side, which is a difficult thing. You have to prove the scope, the existence of the impact, the size of the impact, the amount of the impact, and then you've got to come over the condition and show not roughly proportional, which is the Nolan-Dolan test, not roughly proportionate, but directly attributable. In other words, this is A, B, C, D, E, F, and G, and this is A, B, C, D, E, F, and G. Boom, it matches up exactly. And I don't need to tell you that I litigate for a living, and there's always going to be disagreement over whether this matches up with this. Always. And if there wasn't before litigation, believe me, once you get in litigation, there will be a very good argument that it's not. And given the fact that the burden is on local government, guess who has to prove it? The 4th thing on the other side basically talks about this directly attributable test as applied to public infrastructure. Remember, I told you that one of the reasons why Proffers became in existence in the first place is because the need to mitigate road impact issues and school impact issues, things like that in Fairfax. Well, number 4 addresses the fact that that directly attributable requirement in applying to improvements in excess of the existing public facility capacity at the time of the rezoning seems to reduce the ability to do that. Let's say you've got a development that wants to go in on a certain road. There's maybe some existing capacity on that road, and maybe this new development could use up a substantial chunk of what's left of that, but maybe it itself won't trigger going over to a failing VDOT level. Well, you can't accept the proffer to do anything about that. Because there is existing capacity in that road. That's just it. And then, of course, if you've had somebody else who's already addressed the impact, then you can say, well, somebody else has already addressed that need, I don't have to. A lot of local governments now have fairly common sense rules that say, look, there's a sort of an area that feeds into a certain infrastructure improvement, and we're going to proportionately decide that everybody bears a piece of it, which is generally fair, and most developers have been okay with that sort of approach. That sort of approach is no longer legal. Number 5 talks about undercutting the long-standing presumption of legislative validity, which is in fact what I talked about, the fairly debatable test being turned on its head. Number 6 complains about the penalty. If in fact a developer comes in and says, well, I got turned down, or and there was in fact a suggestion informally by someone in the local government that I have a certain unreasonable condition by a preponderance of the evidence, which is a 51% evidentiary standard. Burden shifts to the local government to prove by clear and convincing evidence that it did not, that was not the reason. That's a very high level of evidence and standard. If the local government fails in that, then the damages, the attorney's fees, and the unconstitutional remand that I mentioned earlier kicks in. And number 7 on the final page refers to that unconstitutional remand. Again, I do not know how, under the Supreme Court cases cited and other authority that I'm familiar with, you can have a judicial decree to a legislative branch to do a certain result, and if you don't, I'm going to enjoin you from enforcing the law. And that's what this statute says. Bottom line is, I've taken a look at this. It is, I think, very difficult to comply with. I've talked to a lot of local government attorneys. I've talked to folks that have tried to work to comply this. I'm very interested to hear our next couple of speakers, because unlike me, who is looking at all the terrible worst things and how we can't possibly but get sued over this thing, they actually have to make it work. So I'm interested to hear how, despite all the problems I've raised, they've solved them, and then they can just knock it out of the park. The last thing in your package there is a proffer flowchart that was prepared by a colleague of mine who actually litigates on the dark side up in Northern Virginia. His name is Andrew Painter. He's at Walsh Colucci. They determined a little flowchart that comes directly out of the bill and is divided into 2 parts. One is determining proffer reasonableness, and the other is challenging an unreasonable proffer. I talked about walking sort of on tiptoe around the lion's den. If you look on the left-hand side, there's sort of a top and a bottom. There's essentially 4 ways you can get out of jail free on the left-hand side and have this statute not apply to you. One is, was the project filed before July 1st, 2016? Good news, this statute does not apply to you, but beware, they may come back and ask for an amendment later, okay? So be careful. Does your project involve conditional rezonings with proffers or a proffer amendment? Well, if it doesn't, then obviously this doesn't apply. Does it contain any residential component which increases or decreases density? If it doesn't, then the statute doesn't apply. And then at the bottom, there's a bunch of primarily, I would say, Northern Virginia exceptions. High density areas, metro rail zones, special service districts, and things like that, which if you're in Northern Virginia, go for it, take advantage of that. If you can find an exception that applies in your locality, you are a winner. But if none of those 4 ways to get out of jail free happen, then you're kicked into the bottom, which I call the circle of death. Okay, and if you go through there, I'm not going to go through each one. It's language pulled directly out of the statute, and as you go from what type of proffer around counterclockwise, look how many ways you end up in the pit, the unreasonable proffer box in the middle. 1, 2, 3, 4, 5, 6, 7. Okay, 7, maybe I overestimated when I said 8 or 9, okay. But there are 7 ways to end up in the pit. Only really 1 or 2 ways you end up with reasonable proffer. That just goes to show you sort of the traps for the unwary, or frankly, even the wary. On the other side, it talks about challenging an unreasonable proffer. I will really commend that to you because I've been up here a good long time, and I wish to let the planners tell you how it's really going to work. I will leave you with just some basic advice that some local government's attorneys have given their clients. I'm not saying this is advice I'm giving you because honestly, this is something that nobody really knows the answer to. Okay, consult your local government attorney. Okay. Many localities are repealing their cash proffer policies. That certainly is advice that many people have given because a cash proffer policy is no doubt some sort of a request or suggestion for a proffer. Some sort of methodology to do a granular analysis of proposed conditions and proposed impacts. As Emily told you earlier, that is something that your locality, particularly in a rural locality, is probably not equipped to do. Even in a more advanced, growing locality, you may not have the staff time to do that. And so having some sort of a study done is probably a good idea. Many people have, of course, amended their zoning ordinances to talk about how people actually do proffers. Some local governments are doing away with them. I will tell you that the proffer game is not mandatory. The statutes say a local government may. That means the local government's not mandated to accept proffers. If a local government chooses to repeal their proffer policy, then, their proffer ordinance, then it's no longer done. And that's certainly an option. Just say we don't want to play anymore. Some local governments have split the baby and said, well, we're going to play in areas that we want to see developed, and in other areas we're simply not going to play there. Defining within your locality who is and is not authorized to request, suggest, or require a condition. Presumably you never require because then it's not voluntary. But who gets to request or suggest? Presumably there would be one person, staff person perhaps, who's designated. I would certainly, out of abundance of caution, never have that person ever speak to the developer or his representatives, which is of course completely counter to good planning and good process. Having your attorney involved, instructing your planning commission members and board members that they are not to request or suggest anything. I've even seen some folks that have said, well, if anybody ever does make a suggestion, then we need to immediately caucus and take a vote that we disavow that request, and that's not a request of the local government. Talk about a mess. I will conclude just with this. As with any legislation, it can be implemented. I'm sure that our last two speakers will tell you exactly how it's going to be done, and it will be done safely and well. But I will say that as a litigator who defends local governments for a living, I'm very concerned about this statute. I'm very concerned about it being used against my clients. I see that it narrows the ability for local government to work with developers and landowners, which I think is a bad thing. I think that, in my view, the statute makes it very difficult for good planning and good process to work. I would think that given how this will, I think, detrimentally impact the development process in Virginia, I anticipate that this will be amended in the future. Whether it will be amended in significant ways, I don't know. But I think that certainly as projects get turned down because of inability to mitigate, I think that there will probably be pressure from the development side to get the thing amended. I think I'm with Eldon. I mean, if it's just us asking for amendments of this, it's never going to happen. It needs people on the business side. So if you have good folks, good developers in your community, and they come to you and say, gosh, this, what can I do? I'm sorry, I can't give you legal advice. No, I can't tell you what to proffer. No, I can't tell you how to mitigate that impact. And they're sort of thrashing around and getting turned down because they can't mitigate. Then what you can do is not a suggestion or anything of a specific proffer. It's a suggestion that you go speak to your delegate. A suggestion that you go speak to your senator. This doesn't work, okay? I'm doing my best here at local government to make this process work. And if it doesn't work for you, then you need to speak to your delegate and your senator and perhaps the home builders of Virginia. Thank you very much.